Mass workers, if your job requires you to go out to eat for dinner and you're injured on your way back to your employee paid for hotel or other site, does your employer have to pay your comp benefits? The answer might surprise you. So, back in 1978, two accountants in Massachusetts were employed to go do an audit at a private school in New Hampshire. So, the two employees hopped in, we'll say one employee A's car, and they drove up to New Hampshire and stayed at the private school to do their accounting business. They were provided lodging at this private school, but they were required every day to leave the premises to go and have dinner. So, on the evening of June 22nd, 1978, the employees left the school at around 8 p.m., not having finished their audit at that time, and went out to have their required dinner. While they were out, they drove in one of the employees' cars to a restaurant located about a half hour, 45 minutes away from the school for dinner. Following dinner, they drove for another half hour to another establishment where they listened to live music, a band, and drank some beer. After about a half hour, the two accountants drove to then another establishment where they played air hockey and spent some time in a lounge. Obviously, a fun night for the two. Shortly after midnight, on the trip back to the school, and at a point about 10 minutes from the school, the driver of the car, the employee, unfortunately flipped the car and killed his passenger. So, a very, very tragic end for the passenger in that vehicle. The issue before the Massachusetts Appellate Court. Now, this is not the highest court. This is right below the Mass Supreme Judicial Court, which is the highest court in Mass. So, this is right below there. Was whether or not, at the time of the accident, the two employees were within the course of their employment. And here's why that's important: because the family of the passenger sued the driver. Now, you can do this. You can always sue the driver of your car for being negligent unless you're within the scope of your employment and you're trying to sue an employee. You cannot sue fellow employees for injuries that they caused to you that are within the scope of your employment. Otherwise, people could claim comp benefits and then also sue their fellow employee. It doesn't make sense. We can't have that. The exclusive provision of the workers' comp statute does not allow this. So that was the one issue before the court. And ultimately, the court determined that regardless of what happened while they were out, where they were drinking or having fun, and obviously going to multiple